Welcome. You obviously must have heard what's in a name. A rose by any other name smells just as sweet. But a name is truly important. And often people ask you, what is your good name? Sometimes I think to myself, did I have a bad name? But this bad name that you can get by other people's, careless tweets is now what you're going to talk. I'll also quickly tell you, since we're on this right now, on Shakespeare, because he had said, good name in man and woman is the immediate jewel, of their soul. So a name, and trust me, when Pradeep Gandhi will tell you more about this, John Doe, we're still giving him a name. Though he really represents, in India, we call it Ashok Kumar, when you make a civil suit against unknown people. But we're still giving it some sort of, a name to go by. So the importance of your name and the reputation that goes with it is something that's almost like a fundamental right. Nobody can take that away from you without there being an absolute cause for it. If something false is said about you, that's when let it be on digital platform. Usually you would normally say the real world is the physical world, the newspapers, the actual publications, which you can physically hold in your hand. And you think that digital is just so ephemeral, you can't see it. People think that what they say is just getting lost in the waves, digital waves, and nobody will notice. But in fact, the digital footprint is far more prevalent. It will remain there in the cloud, as we say, for a long, long time. And it reaches in this super fast speed. It just multiply, viral, as they say. I don't want to make a joke about the pandemic that we have, which is a virus, but it just spreads as rapidly. In fact, more so because one person and it just reaches millions. So if something false or wrong is said about somebody to bring down his or her reputation in the eyes of the other people, and when we say other people, it has to be reasonable thinking people. If that happens, then does a person have a right to take action? Yes, they do. And let's go to Pradeep Gandhi for that. He'll tell you about how in the recent past he successfully.
Thank you, Swati, for giving a beautiful description about what is in a simple parlance, the meaning of the word defamation, and how cyber defamation has become so common, and everyone is just trying to use social media as a vent out their problems, whether they're without knowing the actual truth and trying to defame someone.
True, true.
So let's get back to defamation. Defamation is basically, as beautifully put up by Swati, is someone is trying to defame your image before it should be in either physical form or it could be in a digital platform. The olden days there was a physical form where either in the print media someone was trying to malign or defame someone by putting some derogatory remarks about him, or may send it in the form of a notice or something, or may use slander openly in front of someone, and that would be amounting to physical defamation. But due to evolution of time and social media coming and becoming active all over in everyone's lives, now the easiest mode of getting a defamation done would be through social platforms like Twitter, and just name it, Facebook, Twitter, the social media platforms. So in which you have been quite, I think I'm sure everyone must be seeing that on Twitter, anyone is just taking and venting out the problems. And if someone is saying something about someone, they keep on replying and adding more and more masala to it. And things are getting beyond control. Obviously, it is invasion of a personal right or a privacy of someone, which is being tarnished in the social media, due to which I was compelled to approach court of law and file a suit for defamation, which I call it in my legal parlance as a John Doe suit. What is a John Doe? Swati is smiling on it, obviously, but just to keep all of you updated on this, a John Doe suit is a concept called a John Doe concept, invented in America, where a person who is an unknown entity, whom we do not know the name, and we need to give a name. So that's how in America they gave him a name as a John Doe. And the person who's entitled to file such a suit can file a suit in the name of John Doe as an independent unknown entity, and seek a relief of an injunction restraining that person from further issuing any derogatory remarks or defamatory remarks to stop this issue which is going on. In India, it has now been winded from the past 10 years. The concept was first time introduced, John Doe concept, in Delhi High Court, and that's how in India we gave it a name as Ashok Kumar. Obviously, we need to have an Indian name, so we gave it as Ashok Kumar. And that's how Ashok Kumar suits are filed. They are predominantly, if you observed, my judgment and my reading on this subject is quite wide. Basically, these laws or these concepts are practiced only in Delhi and Bombay. Majority of the time in Delhi, and innumerable judgments have been reported on these issues, which I will deal with it later. But the whole idea is you create an Ashok Kumar as a defendant, as you don't know his identity, and join the other persons whom you know. So for in my case, I just told you the name. The advocate Vibhor Anand was a person who was making derogatory remarks, and there was another lady, I don't know her name, I forgot. She was also on a Twitter handle giving a lot of defamatory remarks. So we made John Doe as defendant number 1. Defendant number 2 was Mr. Vibhor Anand, and the lady was the other person. And I joined all the social media networks as necessary and proper parties as required to be joined under Order 1 Rule 10, because through their social media platform, all these remarks were being offered. So I joined Twitter, I joined Facebook, YouTube, Google, etc., just name it, all of them. I joined all of them. And I sought an injunction for an urgent relief to stop these defamatory remarks. The court heard me, and I cited all the judgments, which I will be discussing at the near future, maybe later. And on the basis of this, the court, upon hearing me, granted a relief that directed Mr. Vibhor Anand and that lady to remove all the past derogatory, defamatory remarks against my client, and also in the future not to do the same. Interestingly, I had given notice to Vibhor Anand and that lady, but obviously for better reasons, they did not come because I had filed a suit in Bombay and they are based in Delhi. But they could have engaged a lawyer and always thought of appearing, because obviously in the legal fraternity, everything is on mail. You can, an advance notice of 48 hours was already given, but he thought it fit and proper not to attend. And the court obviously realized that someone's image is being tarnished on a day-to-day basis, on an R2R basis, forget day-to-day basis. So immediately court granted the relief. The sad part is the social media networks are the tool on the basis of which these defamatory remarks are being done. The court thought it fit and proper not to seek grant a relief against the social media networks, because the court felt it proper that first we should direct the person who has tarnished the image to ask him to remove the defamatory remarks. If he doesn't remove, then I can seek further reliefs, which I shall be seeking in the near future, where I am going to seek a relief against all the social media networks that, sir, I would be arguing this before the court that I have communicated the order, this person is still not removing it out, and therefore I request the Honorable Court to grant directions upon the social media to remove all those defamatory remarks, because they are the intermediaries under the IT Act. So if you have a look at the Information Technology Act, the relevant important sections for discussion today are section 79 and section 66, which is struck down, but I will come to it later. So if you have a look at section 69 of the IT Act, 79 of the IT Act, 79 is very clear, explaining what is the definition of the term intermediary, what is the role of an intermediary, and what an intermediary is required to do, and what are his duties as an intermediary to do in the Act. Obviously, most of the
just that, yes, the intermediaries do have this protection, so to say, an immunity against, being taken to task legally in the court under 79, which I think is also essential. I'm not really, in the larger scheme of things, because it's a platform and it's not for them just to be the devil's advocate. And also that's the law, that you can't really then vet everything that is being, posted on, and they can't be judges of that. And therefore, which you'll come to, and which I'll also say right away, the 79 does, and the court in Shreya Singhal did say that it's only when you have the knowledge that's coming from the court and the court orders you to take it down, or if the competent authority or the government, the agency, then if they don't do that, then of course they can be taken to task, right? I want to know from you, because you're a lawyer and you're practicing right there in the field, how often, because I think that it's not very often that they comply sometimes when the police go to them and say, take it down. Though there are cases, where the police say that if somebody has made a complaint and to take down the content, often it's the person who has posted it who takes it down. But do the intermediaries also respond or do they wait for the court to pass an order?
My experience says that most of the times the intermediaries do not take it down in spite of a complaint or a criminal complaint lodged before the cyber cell. And in my case also, we had lodged a complaint before the cyber cell, and cyber cell very clearly said, we are investigating, we are going to take some time.
True.
And if you want to go and you need to approach a court and take an order, that would be a faster mode. That's how we approach court of law. Because cyber cell has its own investigation team, which will take several days or could be months to do it. And it's going to be difficult finally. So court is a faster mode. So I continue with my discussion on 79. Absolutely right, Swati. 79 is a protection given to the intermediary. But if a court orders, or if the government orders, and if the police orders, then only they can remove it out. Because obviously it could be some defamatory remark could be a defamation for someone, but not for someone else. So because it's a social media, there are going to be pros and cons, and there is going to be pluses and minuses. Someone may like it, someone may dislike it. So therefore, social media plays a very neutral role in this. So unless a court grants a relief and directs them to remove, they will not remove it out. And obviously, as I repeat once again, they have got their own reasons. If they have got more viewership, why should they not continue with it? Because it becomes like a hot masala topic, Their main offices are companies are
Abroad.
based in either abroad, either USA or Ireland or any
Yeah.
other place,
Yeah.
in the European Union. And the Indian company, we join mostly the Indian company. So
True.
when we join the Indian company, they come here and they say, sir, we've got nothing in our control. Everything is controlled by the main parent company in America. So please join the American company. So then we need to take out an application to join the parent company. Once
True.
you
That's
take out the
tougher.
parent company, they come up with a very nice other defense that, sir, we are governed by laws of America, not by laws of India. So even if you pass an order, we are not going to follow your order, because we are not required to follow it. So it's a dilemma, and this type of
It's a
a
dilemma.
it's a dilemma. It has time and again these defenses have been taken in various courts, and one such defenses was taken in, I think, in Delhi I think, Ramdev
Yeah.
Baba. In the case of Ramdev Baba, it's a very landmark judgment. Swati knows
Yeah.
it, and we
Yeah.
all know
Yeah.
it. The ones who've been practicing and dealing with these type of issues. And Ramdev Baba, one of the paras, the last, I think, seventh last para of the judgment, beautifully explains what is the view of the court on this. The court has said the court can't be a mute spectator to this because of these technicalities taken or defenses taken by the intermediary. Whether it is an Indian company or the parent company abroad, finally, when a parent company wants to invest in India and is starting a company in India, it is governed by the laws of India.
True.
And if the laws of India are applicable, they are going to be applicable there also. So you cannot come up with a whimsical excuse that no, I can't control, the Indian company can't control. You better direct the parent company to remove those defamatory remarks. That is what has been explained in that Ramdev Baba judgment. I request viewers to please have a look at it. I'm sure you can press Google and come to know Ramdev Baba. It's a very, very landmark judgment on it. And I don't mind, I'll share with you the citations so y'all can have a look at it.
I think what you could also focus on quickly is about how the people who tweet also ought to know. And there are judgments, and I think in that Jaitley case, in the ARP matter, the retweeting in 2017, a lot of people think, they are not doing it. I haven't posted it. I'm only reposting it. So retweeting of a completely, let's say, derogatory, which is on the face of it, completely derogatory or abusive or has abuses in it, or anything graphic, then the question was that, can you retweet it? So obviously the court said you can't, and you could also be held accountable. Same, I think there was a Madras High Court judgment of a forward. It wasn't a defamation case, but the forward against women was held to be, you know,
Yes, you're right.
I
You're
want,
absolutely right.
I think it would be great if you, you know, also focus on that a little bit.
Sure. See, I just explained to you. Retweeting is basically aiding and abetting. So, if someone has said something which could be scandalous or defamatory, and you like it, and you retweet it by adding your inputs, which are also scandalous and defamatory, amounts to aiding abetting, which is a criminal offense, and it is coming under 79 of IT Act also. So, if you
Yeah,
read
that's
79, it comes under 79 of the IT Act. So it is also amounting to that. And yes, you are right. The Madras High Court has passed an order on the forwardings also of it.
yeah, yeah.
Because the moment you forward it, that means you are also trying to send this message, which is obviously scandalous, to some of your followers or the people who are following you. So that's how it's happening. And absolutely right. So I think that is also defamatory. So let's come back to 79 and the
Okay,
matter.
let's finish
The matter
79.
in
Fine.
hand, yes, sorry. The matter in hand is basically, who are we to comment? Everyone is having their own individual opinion. They should keep it with themselves.
Absolutely.
The moment
If
you
it's
keep
false about somebody else.
right or wrong is going to be the investigation agency's job, not our job. We cannot do it. We cannot. Like, for example, today, the biggest issue today is for the print media and the press and the TV, they've got a device or a tribunal or an authority where you can vent your grievances, and there are controlling measures. So, if you go to television, so there is a Cable and Television Act 1995, where there is a proviso which explains that if you have any grievances for that making a scandalous remark, you can go and approach them, and then the forums of judicial authorities are there. As an interesting case has come up where the usual scandalous remarks were made, and a PL was filed to that effect, and the grievance before the Supreme Court was there is no regulatory body to control them, and therefore the Supreme Court issued notice to the central government, and central government has filed an affidavit saying it is true that there is no regulatory body. We request the Supreme Court to frame guidelines.
True, we've reported about it in times. Yeah, true,
Yes.
true.
So if that be so, obviously in the near future, Supreme Court is going to take it up and will frame some guidelines and set up a proper judicial mechanism for getting all these things issued. Otherwise, what's going to happen is the courts are going to be burdened. You either be a civil court, lower court, high court, or any court. So if there is a proper judicial mechanism, it can be sorted out there. Because as of now, there is no proper mechanism to control them. So anyone is venting it out, and there's nothing, no one to check and balance. High time that social media is now like as a tool for everyone. Everyone has a mobile. Everyone is accessing to all the social media networks. It's high time there has to be some mechanism framed by the government or by the Supreme Court, and so that these things can be controlled. So that is what is basically on the defamation front. Now, I don't need to explain. Defamation can be civil and or criminal. Civil, I have explained to you what is civil, and criminal is section 500. It's a very simple section 500 of IPC. Criminal
True.
defamation is also a punishable offense for which the necessary authorities, like approaching a metropolitan magistrate, which is the normal authority who can deal with it. You can file the basic prerequisites are give a criminal defamation notice, after which lodge a complaint, and let the court decide it whether it's amounting to a defamation. And if the court comes to a conclusion it's amounting to that it is amounting to a criminal defamation, court will issue fine and all punishment and all both, whatever it deems fit and proper, within the
It's up
framework
to
of
two
section
years.
500. Yeah, within the framework of section 500. So that is the whole issue. I think Swati, can you just add something more?
Just to explain, since we are talking to students, I believe. So defamation, of course, like Pradeep said, written is libel, oral is slander. Written can be in physical form and all, like we said. It can also be on the digital platform. It's a non-cognizable offense. Only I, if I am defamed, can file the complaint, not the world at large, not the police on its own. It's not a serious cognizable offense under the IPC. So I file a complaint, and then the magistrate decides that yes, there's some merit in it. And then he's supposed to issue summons to the other side. I have to make out a case that I have been defamed because there are people who sort of, it maligned me and it brought down my load, my reputation, whichever frame of work or health or whatever it could be. Yes, the punishment is only up to 2 years, but any amount of jail is jail. So the punishment, if it's 2 or 10, if you spend some time in wrongfully in a jail, also is not right. There are some exceptions, right, to defamation. And so, for instance, if you're covering courts and writing the proceedings of what goes on there, then you're protected. Or that can be the defense if somebody still decides to take you to task or to court or file a complaint or take you to the court in a sense. But an innuendo, you must remember, is also can also be defamatory. If you think that you're not named a person and you're safe, it's not true. Because if you can identify that person through the writings, it can still be a case of defamation, right? What are the things? An opinion but is not defamation, largely. Because when you talk about false, what can be false is only a fact. An opinion, can it be false? So you can have an opinion about something. It may be in bad taste. And should you do it? Perhaps not. But is it completely defamatory, an opinion that you hold about a person? Maybe not. Celebrities, okay, are open to a little more, let's say, comment. Okay, you can say something a little bit more about a celebrity in public life. Because the fact that he's a celebrity and he is a public figure, but does that mean you can also then make false statements about him? No. Like just what happened, right? In Pradeep Gandhi's case, you have a client who's, in effect, the case that we just mentioned. So false statements that lower, right now there's something else in the High Court. One actress took another one to court saying that, look, you defamed me by saying something which, is in the eyes of her fraternity and the whole world, it puts her in let's obviously, lowers her reputation as an actress, as a woman. So of course, that's probably going to be going in a way which is amenable to both. But she could take the person to court, even though she's an actress. And I just said you can't talk about it. When I say you can talk, if there's a book and the book you can comment on, because you can write a review about it, you can trash it, you can say it's bad and I don't like it. You don't like it as your opinion. But if you said that the book was written with a particular agenda, which is not correct, I'm just giving an example from the top of my head. If you're making a false accusation about the author on why he wrote it, then it could still be defamatory. Same goes for a movie. Same goes for, any other examples that I can think of. But okay, let's just sit. Why are we talking about defamation? Why is it important? It's important because it's linked to your freedom of speech and expression. And that's a very important right that you have, right? Your freedom of speech and expression. The fact that we're sitting here and talking all this and nobody's saying, hey, wait, you can't say this and you can't say that at the moment, so long as it's not defamatory. But is freedom of speech and expression completely unbridled? No. And that's the Constitution which says that you can have laws but the laws have to be reasonable, which can curb it to an extent. And what are these laws then, and when can these laws be passed? Only if it's a question of law and order, public order, and friendly relations with neighboring states, the issues of sovereignty, right? It can't be, I think the Supreme Court has said this in Shreya Singhal, it can't be that you make laws in general public interest to say that, oh, you can't say this and you can't say that, and if you say that, and that's the reason why, I'm sure Pradeep will get into this also later, 66 was shut down, because it was very widely worded, is what the Supreme Court held. It was so wide that it could just encompass anything that, anything could be termed offensive or annoying. So the freedom of speech, like I'm saying again, is a vital right that you have as a citizen, as an individual, to be able to speak your mind. And again, 19.2, which is the article of the Constitution, kicks in and can curtail your speech. Like I said, if it leads to that public disorder, if it leads to some sort of a violence, not all the time, that should lead to violence, but these are the reasonable restrictions that the that the laws can put against you. And that's why 66, because we're talking about cyber defamation. But the feeling now amongst the practitioners and others is that, look, now with 66A no longer there, it sometimes becomes difficult to take on these people who are happily or merrily, spewing venom, saying completely wrong things, complete falsehoods on posts on the digital platforms, and they do it in a manner which they think is anonymous. Trolls, they don't have their own names ever put on it. They all have some other pseudonyms put on it. So they think it's very easy to say something about a person and get away without realizing that you can and you are harming the person's reputation. And that's where you have the civil remedy, because the criminal process under the IT Act is still a long way to go, right? It's not very easy to get criminal actions kicked in. There have been cases recently where FIRs have been filed for, defamatory statements made on Twitter. Persons do get arrested, do get bail, and why not? But if that offending tweet or post still remains there, and it is viewed day after day by millions, and it can be viewed by millions, the fact is, so there's an interesting debate also that, whether it should be nuanced. In UK, for instance, when you tweet, is it only your followers who read it? Because it can be open to the world. Your followers can read it, and the world can read it. So who are the people reading it? How do you judge? Because in defamation, you try to say that, it's a reasonable mind that has to interpret something as being, defamatory. So in Twitter, for instance, since that's now becoming the most, well, even Facebook posts, right? Are only your friends reading it? Some of them don't have this kind of, settings, and your post can be open to the world unless you have a privacy setting in your Facebook, your page, or your account. Same goes for all the other. Instagram. I mean, a lot of people take to Instagram. There's now Telegram. There's just all sorts of grams. And grams are basically methods to send your message to the others. But that message, if it's an intentionally, false message, then are you doing it with that intention? How does the world know that? And how does he protect himself? The person who's facing the brunt of all this. So that's when you go to the court, and the courts have to then, since the criminal law won't do it, the civil law will say that, at least for the time being, bring it down till the matter is heard and decided, and seen whether it's actually really a defamatory statement. One of the first cases in UK where the BBC made out an article about, and they didn't name the minister or they didn't name the politician, and they said something about it. But another person, based on that, tweeted and said and named the person, and then put an innocent face. And it was found out later that no such thing actually was established against the person. So the court imposed heavy damages on her, and she also accepted that it was a woman. She accepted that what she said wasn't true, and I believe that was one of the first cases there some years ago. In 2000, in the US also, they initially, because of the internet, there was this conundrum, how do you deal with this? How do you deal with words that are being put out and why are people putting it out? Because people, like I'm saying again and again, they think that they're safe. When you see it in the physical paper, or if you're saying it, or if you're putting it on a pamphlet yourself. Defamation, by the way, can also be by words, signs, just gestures. Don't think that you can make a offensive gesture and get away with it. Also, what I think I don't know if I said this. If I didn't, let me correct it. Defamation is only when it is published, and that publication means a third person has to see it. So when, of course, you put it on Twitter, you get millions can see it. But if I say something just to you, that's not defamation. If I say the same thing and I mark CC to somebody else, or I shared the post with somebody else, then that's when an offense of defamation can kick in.
I was just contemplating as what is the judiciary stand in all of this? Baba Ramdev is just one of the examples, but are there any other cases which have come up before the courts, and over a period of time, how have they dealt with it?
Most of the cases which are reported in most of the law journals are always in favor of the person against whom defamatory remarks were made. And up till now, they have not yet reached the stage of final hearing. The
Yeah, a
reason
lot of
being, my experience tells me that this is, as an ad interim or an interim measure. The moment it reaches a stage of final hearing, as explained by Swati in that issue with Arun Jaitley and AAP, with Jaitley and AAP, it was a
right.
full-fledged trial going on in the Honorable High Court in Delhi. It went on for 20 days. Sorry, that was Jait Malani and AAP. And that matter finally got settled because the judges prevailed over both the parties, saying that you are
Yeah, I
just
think that's,
making
yeah, this
derogatory
it's,
remarks. This is a matter which can be resolved. Let bygones be bygones and forget it. So most of these issues are not reaching the stage of trial.
yeah, that's true. I'll tell you one case if you want to know. It's not a case of trial. It was in the High Court of Bombay, where a company can be defamed, by the way, where a company came to court saying that, hey, take down a vlogger, a video blogger, a vlogger, who basically puts out videos about products. And the company said, look, it is very derogatory against us and against the product. And the High Court, because like I'm saying again, your fundamental right to freedom of speech and expression is a very high and, as the term suggests, fundamental right that you have. Can it be curtailed, and when can it be curtailed? So in this case, the High Court said, the High Court really said that, change some of it, change some of the contents. It even suggested things like, don't say rotten or poor quality, or or things like that, or inferior. Remove these words from your blog, but he let the blog remain. And that, to my mind, is a boost for people and for anybody who, in upholding the fundamental right to freedom of speech and expression, because that's not a right that should or can be taken away lightly. Supreme Court in the Sakar newspapers, which is a landmark case, had said that content really, can it be regulated by government? No, it can't. Um, from what I remember, the exact words, I'll pull it out and I'll share with you later. But that's one very vital judgment. In the High Court right now, there are these issues going on about, I think Pradeep mentioned, where again, it's actually a slightly different issue, but again, the freedom of speech and expression comes in there. And they're trying to argue that the government can't indirectly bring in some law. It's about channel pricing. The only reason I'll quickly mention it here is because they're trying to argue that if you're putting a price curb on channels that you get at home on your cable TV, then it will have an effect on content. And content means freedom of speech and expression. So they're saying that is something you can't do.
One
Yes,
very important judgment is SMC Pneumatics versus
Yeah.
Jogesh
yes,
Kawatra. That's a
yes,
very, very landmark judgment on
yes.
cyber defamation. And I
It was one of
request
the
all
first
the
ones I
viewers to
recommend.
please have a look at that judgment and you will get a better insight on cyber defamation.
Also, I would say to both of you that ultimately what you both are coming to the conclusion is that there is a very fine line between defamation and free speech. And to determine the same, it would be important to determine the content and the words that you are using to
Absolutely.
draw that fine balance.
Absolutely. Because it's all about the
Absolutely.
words.
Absolutely. I agree with you, Sunita. Finally, I would always like to, say one word.
Yeah,
Every person should be responsible in his statements.
absolutely. You said it,
Before,
Pradeep. I think people should not think that they can get away, and it's not an offense, because until it comes to haunt them, if somebody says that, then they realize how important your reputation is. Often it's the asset that you have. It's the most vital asset, I would say, your word or your reputation, and it's not something that can be trifled with easily by
Sure.
anybody.
Sure. There is also the issue of cyber harassment. What are your views, both of you, on it?
Pradeep?
Harassment. Cyber harassment, can you just, Sunita, I didn't get in what context you are trying to just say.
So, just as you defame, you can also keep making remarks about a person on Twitter or Facebook, and
Stalking? Are you talking about? Yeah. Okay.
it can be
Not
stalking.
stalking.
It
Mm-hmm.
can be stalking, it can be slander, it can be libel, it can be making derogatory remarks, but not offensive, not overtly offensive. So, what are your views and how?
See that Madras judgment, in fact, like I said, it didn't deal with defamation, but somebody had made comments about women, and it had become a huge thing, and which was the forward, actually, a WhatsApp forward, which was shared
There's a landmark judgment on cyber defamation.
in 2018. Yeah.
It's called Kalandi Charan Lenka versus State of Odisha.
Should we read
That's
it?
basically cyber harassment would mean that someone is constantly harassing you by nagging and retweeting or doing passing scandalous or defamatory remarks again and again, which becomes an harassment. So it is a corollary to the defamation. If you go by the actual term stalking in IPC, the word stalking is very, very, very different, because it's like someone is watching a female or a woman in a different manner and
Yeah. Let's
continuously following her
in various forms
everywhere
online.
in various
Yeah.
forms, which is causing a lot of harassment and inconvenience and obscure for that lady, due to which she can go and approach the police and lodge a complaint for stalking. Now that
Correct.
is stalking. But if you connect that with stalking with cyber crimes, it can be, yes, but there can be a very different instances. Like for example, through Facebook, someone makes a friends with you, or get you get through someone hacks your Facebook account and gets in and is stalking you and trying to find out all your data and details and who are you, where you've studied, your whole bio data, and what is your movement. But everything in on cyber is basically controlled by you. So for example, if you're not very active on Facebook and don't share any of your personal details, which can be obviously controlled because there's a privacy settings, or even otherwise, like there are a lot of people who are in the habit that even if they just go out for a walk, they click a pic and they put it on Facebook. No, that doesn't make sense. So why are you trying to put your private life into social media, which becomes easily accessible to the public?
Sure.
So cyber, I can say harassment. Harassment, yes, it can be done, but it's a very relative term. I would say it's a very relative term. Swati, your comments?
Harassment is, so I'll tell you, 66 was used a lot for harassment and annoyance. So that's one, that's the that's what lawyers say, and even cops say sometimes, but I'm not at all for reinstating it. The Supreme Court judgment is absolutely right on that. So what are the other? Intimidation? You can put that, right? If it's a woman, it's 504, 505. And these sections are invoked by the police, even if it's online. If that's what you're saying? I'm just trying to also pull out something. We don't have an act that's really there to protect individual privacy, which is what Justice Sri Krishna in his the whole report that he did, and the data protection law, actually.
Sure.
Well, privacy is a fundamental right, of course. The data protection law is still yet to become a law. And once that comes into place, perhaps there'll be more protection.
But also to take it further, Swati, there are instances where people have been filmed in situations where it's not just lack of privacy, it goes a little step further. And as a matter of revenge, it is posted on social media platforms with the name of the person. What are the remedies in such cases?
I think we'll visit 79 again. It talks about due diligence, right, Pradeep? So
Yes,
what is the
but
due diligence? But
due
that due
diligence.
diligence doesn't cover judgment of content. Again, that's the problem, right? So if somebody does that,
If it is, like I've come across situations where some private moments of someone have been recorded, and
Yes.
someone has got access to it and he puts it directly on a social media. Now, obviously, it is obscene. Then
Yes. Yes.
provisions of IPC come into picture.
Yes.
Provisions of IPC come into picture, including IT Act, read with IT Act. Around 7 years back was having no control on it. Last 4 or 5 years, because of these continuously complaints being received by Facebook and the government and the cyber cell, they have come up with a new artificial intelligence where the moment an obscene visual video is coming, the artificial intelligence automatically stops it within a few
Yes,
minutes.
yes.
My view is very clear. If such a someone is trying to take the social media and trying to uh, you know share some personal information or some video which is really private or obscene, the only remedy available is approach the cyber cell and who would lodge IPC complaints including IT
Or
Act, and they can investigate, and obviously we can address a letter to the social media network, to the service provider, to remove it. And normally in such instances they do remove. They don't
yes, they
wait
do
for
remove.
any derogatory remarks like how in a defamation matter they said nothing doing, go to a civil
Yeah.
court, we can help you. They will immediately remove. They'll take action on it very, very clearly. And in fact, now if you go and see the settings also, check out any of the settings. They have come up with some proviso where if you find it objectionable, you can immediately put your objections by approaching setting, putting your remarks, and they will immediately deal with it immediately.
Sure.
I
You
think
recall.
we, I think we had a story recently about how the number of cases during the lockdown, as Pradeep said, more people are using the online platform to vent, and ventilate. The cases have gone up, but the police have said that they've also got many to take down offensive content from the online platforms. So the person themselves.
Let me take the questions. The first question is, when jurists often say that preservation of electronic evidence is difficult, what does that mean?
So I tell
When
you, if it's electronic evidence, Sunita, if it's on my phone, there's something. The phone is often taken by the police, and it requires a certificate of authenticity
Called
that this
65B.
message is 65. Yeah,
B,
section
B,
65
B,
B.
B for Bombay.
So that B for Bombay. So that has to be done, and then it can, if it can either be in your favor if you know that as evidence, or it can be used depending on the case and the circumstances. But that is very important, and without that, right, the evidence becomes inadmissible.
I would like to add
Um,
with
yeah,
Swati's comments.
yeah,
See, normally on civil matters, I'll just share what my experiences are. Like, for example, I take a printout of a court order. Okay. Now, under the IT Act, the moment I give a copy of the court order, actually that is not admissible in evidence under Evidence Act. You
yeah.
require
But yeah, you're
it
talking about
to,
civil matters. Yeah,
yeah, so you require to explain that in your evidence as to how you got in custody, which is your
yeah.
PC, what is the make, what is
That's why
the
65B.
that's yeah. That's your what's your printer's the model number and the company. And when did you remove printout? From how did you get access to it? That has to be explained. After which, that's called a certificate under 65B of the Evidence Act. And that
And that
certificate is legally, if it is proved, then it is legally admissible, and that document can be exhibited.
for
Great.
criminal cases, for criminal,
Same
and
thing goes for
this,
criminal also, because Evidence Act is common for civil and criminal.
yeah, yeah, yeah.
To what extent does deciphering the identity of person, making a comment or a post on social media by means of section 200 and 202 of CRPC, whereby the court can request police to conduct inquiry to trace identity by locating IP address, how much does it really work in the real sense?
So this 200 and 202 again. So since defamation is not a cognizable offense, you go to the magistrate. It's in a sense a private complaint. The magistrate then has to pass an order. The magistrate can either conduct its own inquiry, or can direct the police to then register an offense, which then becomes the FIR, etc. There are many cases, no, where people do go and
But
cases are registered.
So in my view, the court has a power to direct the police to investigate and call upon the and police is required to go to the company, the intermediary, and find out all the IP addresses and give all the set data
Yeah.
to show the link, to show the link as to how the case is attached to the IP address. And if that has been determined properly to the satisfaction of the honorable court, then the court can register a offense and also convict the person.
Yeah, the IP address is essentially like the footprint. It's your address. It tells you which. So we are speaking on all our devices today, right? And I'm connected to a particular Wi-Fi, right? It gives you the exact location. That's it. It's all in digits, but that's like the home address that you have. You know, you say you're staying in Pali Hill, bungalow number so and so. That's exactly what happens on the digital format. So don't think that, since you can't see it, it's not traceable. It can be. It sometimes takes time, and sometimes it's difficult to trace if the person is very clever.
Normally, the police is duty of the police cyber cell department to find out all this and show it to the court in case of any defamation complaint lodged and pending before the court. Otherwise, if it's a simple complaint directly addressed to the cyber cell department, then independently the cyber cell department will find out all these details, and upon drawing conclusion that yes, it is a defamatory remark, they will initiate action by lodging an FIR under whatever provisions.
The next question is, if you are YouTube or TikTok trollers, are they protected even when they use abusive language?
No, they're not. Come on, trollers. I mean, that's the whole thing, that it's just that, not everybody is taking action against everything. Sometimes it's best to ignore something. And a lot of people do that if it's not immediately, affecting you. But some cases, one ought not to, and one doesn't. And that's where they go to the court and try and get an order to restrain this publication from continuing or, being shared. Because the danger is always that it can reach a wide and the widest possible audience in the least possible time.
I'm in agreement with Swati. Absolutely right. Bullseye, Swati.
And that's why you need to get this restraint order.
The next question is on rape threats or death threats. I think you've dealt with it, wherein you said that artificial intelligence has not been implemented as regards use of certain language and words. Am I right?
So what Twitter does, sometimes it'll show you, right, that your sensitive content, or they sometimes ask you to do a quick check to test whether it's you, right? I think these are all aimed at ensuring that you don't put out through AI, like Pradeep said. Some words, I guess, are checked. But a death is not it's a common word. I mean, it's in every news story. So, 2 people died. It doesn't become an offensive word. It's always the context of the words that are put in. Yeah, that's again why you have to go to court and based on the content say that, look, this is defamatory, or this is harmful, or this is, harassment. And then the court can pass an order that you've got to take it down.
I agree with Swati, with one rider, very rightly put up by Swati, that, I'll just explain to you normally what my observation is on artificial intelligence. Like, for example, something which is affecting the security of the nation, something where anti-national sentiments and words are put, the artificial intelligence has been trained and coded in such a manner that immediately it will catch it. And they will say it's defamatory, we are removing it out, or they'll put a rider upon you that beware, you're doing this. So it's a disclaimer. But when it comes to death, this is a very common word used. So there is no control measure of artificial intelligence on death. And rightly said by Swati that person who's aggrieved should go and approach approach a legal remedy by going to the cyber department or courts or asking, etc., etc.
But again, it's not that everything that you say, and if you somebody goes to the court and seeks an order, it ought not to be, and it hasn't been granted by the court, because the courts say that, I'm going to repeat it again, but the freedom of expression is a vital right. It happened in one case where the Supreme Court said that if, there was a game made out online, against a certain company, and the company goes to court and says that, look, this is defaming me. I mean, defaming us, and they're using our sort of logo, etc. There are two elements of it. One was the sort of the trademark or violation, but the defamatory content is what they were opposing and saying it's offensive. So the court said no, because, and this is online, because something that can be said as a hyperbole, as an exaggeration, it's not defamation. And it was very interesting. It was a very interesting and important judgment where the court said no relief, no stay, no restraining orders to take it down, because, and of course, it's slightly different here. It's not against an individual and his or her personal reputation, but it involves some sort of a public purpose or the project. And so the court is saying that, look, you have to be able to have discussion. If you restrain, I mean, the argument was also that if you just restrain this one entity, you could be then, have a chilling effect and gagging all kinds of discussion on this. And so the court is saying that it may not be necessary to say that this is completely false right now, but if it's justified in making a statement, then the courts need not just come and say, hey, just block it, police get them to remove it, order the intermediary to take it down. Not necessarily all the time. Hyperbole, like I'm saying, it's a very important, when you
I would like to
exaggerate
share one
something.
example, Swati, if you don't mind.
Just quickly, will I tell you? I found it interesting. Sorry, this was
Very nice.
on the
Really, I really
Oprah.
appreciate.
It was on the Oprah Winfrey show, and sorry, Pradeep, just a quick. It was during the time when there was a mad cow disease or something, and there was a discussion. Somebody took the speaker from the audience and Oprah to court, and said that there was defamation and all that because they linked the mad cow to AIDS. And so the court said, no, it's just an hyperbole. It's just an exaggeration. It's not defamation. It's not defamation. Or the cattle industry in the US took it. So they said it's not casting aspersions on you. And then of course, during the debate and the talk, Oprah said that's a very extreme remark. So you have to take it, and it's all really on a case by case, on the facts of the case, on the content. So there's not like a really a hard and fast rule on.
It's also, as you rightly pointed out, the context in which it is made. The next question is on liability of a person forwarding defamatory memes. Now, if you recollect, there was a meme of a political leader of East India, which was forwarded, and subsequently the student was jailed. Now, what happens if you forward a meme which is defamatory of a person? Is the liability not the same as a forward?
Forwards can have a liability, which is what the whole
Madras High Court said.
Madras High Court said. It was a forward by a guy, and the High Court said that you can't escape liability just because you are forwarding something. Forwarded as received. Wasn't it also a recent thing? You can't just say forwarded as received and say it's all going to save you. It's like saying that, oh, it's not my remark, I'm just alleging and I'm going to attribute it to so and so. So you're repeating. It's like a retweet. If somebody said it, something wrong is said, and you repeat it, it's the forward is the same thing about the court has held in that matter. And therefore, in that case, it was, I think, anticipatory bail, and he had rejected it. It was a question of anticipatory bail. In fact, the court had said this forwarded message has shaken the entire society in which women hold an equal citizenship with all rights, with gender disparity. So it was about, and it was a forward.
Once again, it depends from case to case also. So
Yeah,
as
it
rightly
does.
said by Swati, Madras High Court took a view of forwarding as it's amounting to an offence and rejected the bail. But it depends from case to case. Some other state may take some other court may take a different view.
Trying to see.
There is no clarity as of now on a straitjacket formula framed by either any of the courts of the state or Supreme Court on this issue. So this may come in the near future. I am sure we'll get some answer maybe in the near future.
Swati, the next question is actually directed, you would be best in a position to answer it. It says, it is often said that freedom of the press is an auxiliary right under Article 19 itself. However, from the decisions of the court, does the press somehow have greater immunity in this regard, especially since it has a bearing on cyber defamation?
Say again, how is it linked to cyber defamation? No, so Okay, in India, unlike in the US, where it's freedom of press is a written word in the US Constitution, in India, the Supreme Court has, by its interpretation, held that freedom of press is a fundamental right. Okay, but that again, it doesn't. Like we just spoke some time back, we have the press council, etc. However powerful or not that they may be, there are ground rules on how to report. There's responsible reporting. Defamation is an offense. People can be and have been taken to task and to court over it. Um, the article that may appear in paper, if it's printed online, is that the question? The fact is, it's an article, and if it's defamatory, there have been, and like I'm saying again, there can be action taken.
The next question is directed more towards you, Pradeep. In a matrimonial dispute case, wife always says, this is the person's comment, wife says unnecessary things in her DV petition or 498 FIR. Can the husband file a defamation on this point?
According to me, no.
No.
The reason being is that the court which is having the competent jurisdiction, that is the family court, which will decide whether it is actually said or not said. So till that time, you cannot take a defense case, it's a defamatory remark, and therefore action can be initiated by another court. Otherwise, it would happen that two
No,
courts will give conflicting views and would create more and more of confusion.
what did the wife do? She made a remark against the
In a
husband, is it?
Yes.
But to who did she make this remark to?
She makes
So,
it in
the petition, in the divorce petition.
the DV petition.
Oh, and the petition. Yeah,
Yeah.
like Pradeep said,
Okay.
the court has to first decide. Yeah.
Would both of you like to talk about any of the international cases which have, which you think are landmark and which somewhere down the line could be applicable in India?
Okay, like I mentioned in the UK, that first case, it was for online, it was one of the cases that set the tone of courts, getting into the tribal, as Guardian put it. I don't know if it took off, libel and Twitters. But there have been cases subsequently in UK, for instance, where damages have been. So in UK, one must remember, there's no criminal defamation. That law it no longer exists, unlike in India, where we still have it. So this only claims can be made for damages, right? In the US, there have been cases. Well, what comes to mind? Sunita, I'll just get back to you on that in a minute.
Okay? No problem. Pradeep, what about you? Can you throw light on any international?
As of now, nothing offhand, but I would like to share that, see, India, things are very different. We are a very vast populated country. We are a third world developed, not yet developed country. You cannot even compare us with UK and US, where every law is so highly developed in UK and US that, especially law of torts, since this discussion is on defamation, which is on torts.
Yeah,
So
the
the
civil defamation.
Law of torts is so highly developed and defined so beautifully by umpteen number of judgments in UK and US that there is,
Okay.
even if someone spits on you by mistake, and he can just straight away take you
No.
to
Okay,
court.
I remember this one. So malice, okay, or falsehood, okay, is a very heavy burden. This is what the Supreme Court, in the US has said in one case. Proving actual malice is a heavy burden, and that's a fact, and that's the law even here. Proof that a defendant, the person who has made some such false remark, has made this false statement is not enough to show actual malice. Okay, and why are we talking about malice? Because the statement has to be made with malice. If it's made in good faith, that's one of the defense in criminal law of defamation. That if the statement is made in good faith, without malice, then
So intent.
So yes, and so the Supreme Court there made it clear that there's a significant difference between proof of actual malice and proof of falsity. This was in Bose Corp. Proof that a defendant spoke out of dislike or with ill will towards another person does not automatically meet the test of actual malice. I may not like you, so I said it. So you can see how nuanced and high the bar is for
Sure.
proving actual malice. And why is this all again, I keep saying, is because the fundamental right to freedom of expression is not to be taken away from a person so lightly. Even if the statements are shown to be false. This was said in Garrison versus Louisiana. If a publication is undertaken in good faith, for instance, failure to investigate the subject of that publication, I'm just reading from some of the judgments, will not in itself establish actual malice. That a defendant publishes statements anticipating financial gain fails to prove actual malice. So you can see how high the bar is, again, I'm saying.
Yes, we've clearly defined it.
Yeah, this was said in Hart Hanks Communication versus Connaughton, something. There are some more. As long as a defendant, and who's the defendant? The person accused of defaming somebody, does not act knowing his statement is false or with reckless disregard. The force being on the word reckless disregard of its truth, actual malice will not be present. He should know that he's making a false statement. That's the reckless disregard to truth, right?
Sure.
That's what one should guard against when you're making. And like Pradeep said sometime earlier, people should be responsible. You know, we think that it, and like I'm saying over and over, you think, and this is what people think. I'll quickly read out to you what I did mention about hyperbole. I'll quickly read out to you another para. Pradeep, do you want to say something? And then I'll pull out this para.
No, actually, I don't have any judgment on hand on US courts or UK courts, but my view
UK
is
is, yeah.
very highly developed. Both these countries being so highly developed, the laws are also highly developed. So even one small mistake of a defamation is taken to courts very seriously, and decisions are granted
In
immediately.
in the case that I mentioned earlier in the Supreme Court, it was argued by the company against this NGO that the NGO said, you know, this is a strategic lawsuit against public participation. It's popularly known as SLAP, because to ensure that there's no talk or debate. Um, so it's not that law is always against a person who's, you know, reckless and has to be chilled, put in a chilling effect. But I'll just tell you one quick thing. In one of the US cases, in, I think Dow Jones, it was submitted that unlike publication in print media, which can cause the same intensity of damage to the individual, the reach of the internet and its widespread accessibility means that any defamatory or libelous material posted on it causes greater damage and harm to the injury of the subject. Therefore, courts have to view this aspect from a wider perspective while dealing with it. And that's where they pass these interim orders, you know, because you have to look at the balance of convenience. If the matter continues to remain online, you know, if there's a likelihood of irreparable damage, then the courts pass it. But if the courts say that no, this is in his right of, you know, there's no breach of, it's not defamatory, it's not false, it's not going to harm the reputation, just because you come to court, I can't gag the person or gag the media or gag the online handle or the Twitter account,
Okay.
right?